Okay, Mr. Martin.
Morning, Judge Higginson, Judge Willett, Judge Hell. Pleasure to be here again. I will tell you that normally when I'm here, it's because my practice is in Admiralty here. I work across the street, and I am not going to try and offer any sort of complicated arguments today, as in the preceding case. I'm going to talk about very simple concepts and why, in my humble opinion, they should apply. My clients are here. They are very interested in these proceedings, so if you're wondering who they are, that's Dennis Nelson and Kathy Nelson, who I invited to see the court function today. We are here because I lost a motion for summary judgment, and Senior Judge Sterrett in Hattiesburg said that as a matter of law, based upon the four corners of a label, my clients did not have a claim. Now, I would respectfully suggest that Judge Sterrett's wrong. Summary judgment does not require me to prove my case on the merits at a summary judgment hearing. And every doubt as to evidence every inference is in the non-mover's favor. That's old law. But what we have here is not just a simple case of a label. If the court looks at my brief, pages 4 to 6, somewhere in there, there's a chronology of events which detail what this manufacturer knew about its product and what was wrong with it.
We're going to start with the failure to warn?
Sir?
We're going to start with the summary judgment on the failure to warn claim?
Yes, sir, we are.
What I guess for me it would help if you just went right to Fortenberry, the Mississippi Supreme Court decision that the district court cites, and then in the red brief it's sort of what they're saying, which, as I understand it, is Mississippi saying pretty much cookie cutter labels are okay.
Well, they're saying that, but there's a problem here.
Okay.
When you look at the very first section of the Mississippi product liability article, it speaks in terms of a manufacturer seller who knew, or in light of reasonably available information about a danger, is supposed to warn of that danger.
Yeah.
Now, I've called this a Ford Pinto case. Ford probably warned people back in the day that if you're hit from behind, you're going to have structural damage. Didn't tell them your car would blow up. This is a case where they knew.
Here they do specifically say fracture and perforation.
That is true. They do say that. But what is important here is, how does a learned intermediary physician understand truly what the risk-benefit ratio is to his patient if the truth about the failures and the deaths are not provided to him? And there are loads of ways to do it. For example...
Well, that's a powerful argument, sort of policy argument, but I guess I'm asking you, your position is that the rule of law in Mississippi post-Fortenberry is that they still have to warn about complication risk or comparative device risks. What's the case law that says you don't have to just actually say it could fracture, it could perforate, but that happens with this level of frequency, or these other devices do it less? What's the law that says that's got to be in the label?
There is no case law there
yet.
Okay. But here is the problem. There is a conflict between cases such as Williams versus Manitowoc Cranes, Judge Willett, you were on that panel, where this court said in Mississippi a warning may be held adequate as a matter of law, where the adverse effect was one that the manufacturer specifically warned against. That's what you just said.
Yeah.
But here's the Paul Harvey. But there is no bright line rule for whether a warning is adequate. Typically, a jury resolves that fact question. Those last two words are important, fact question. That's what we hear about, a contested issue of material fact. Now, this opinion does not say to me that the ruling on the four corners of the warning is the end all. It says to me that it's a fact question that the jury has to decide. Now, the other problem here is that there are a line of cases in Mississippi from their Supreme Court which say that the product advice is given to a learned intermediary. And if the learned intermediary testifies, had I been possessed of this information, which in this case was deliberately concealed, okay? That's what makes the difference here. That information would have changed the learned intermediary's
I
mind.
thought it was up on that FDA MAUD database, that if you want to look at the frequency of sort of failure rate, it's there.
Well, first of all, the law does not require doctors in making these decisions to do that. Mississippi doesn't require it.
Right, but you said it was concealed here, and I'm saying I thought the record showed they actually did report the failures.
They have an in-house report called the HHE, Health Hazard Evaluation, and it was done by their in-house medical director as a result of horrendous medical reports of failures and deaths. And 6 months before my client got an implant, which, by the way, left him with a metal sliver the size of a hypodermic needle that passed through his heart and is now permanently lodged in his pulmonary artery.
Do you
They
know,
knew this.
does the record reflect that any company's filter on its label actually warns about frequency of failure rates? Do you know of any?
I am not aware of that. That is the problem here. If you hide behind a law that says you don't need to do it, then you can get away with anything. And that's not right.
Yeah, well, it may be Mississippi laws got very strict, because this was what was argued in Fortenberry, right?
Well, I understand that, but let me take this a step farther. How could these other lines of cases, the fully informed learned intermediary sort of cases, how could they exist if the rule was simply look at the label? This is a case where we deposed the doctor that did the implant.
Yeah.
And he was absolutely astonished when he learned about all this information that was not provided to him. He said, not only would I have not put that device in Mr. Nelson, I wouldn't have bought it or used it. And he brought up another really important point. How can you get the informed consent of your patient when you haven't been given the truth about the product? And that is something that can be resolved simply. Let a jury decide.
You're saying Mississippi law, in spite of Fortenberry, requires which? The frequency of failure as to that device, or comparative data as to other devices?
First of all, we never asked this court or the court below to create a prospective duty on the part of the device manufacturer to constantly be comparing its
Which are you arguing for here? Where's the error by Judge Sterrett?
All we asked Judge Sterrett to do was say that this information, which was already on hand, actual known knowledge of failure rates, not possibilities, because
So complication rates for the device, not comparative
actual
device.
facts, known facts, which under the law.
I'm asking you the same question again and again. The warning would be the failure rate for the device itself. There would be no obligation to put in the label that other devices fail less frequently. Or are you arguing for both, that the label has to say both?
What I am saying is that if the information is known, it has to be disclosed. If the appropriate method of doing so is on the IFU, that's one way to do it. Another way to do it is what Allergan has done in the rough-textured breast implant cases, where it pulled its product off the market and sent a letter to every woman who'd gotten its implants, advising them that these things potentially could cause cancer. Another thing that Bard could have done here, they had a series of Dear Doctor letters. They sent a Dear Doctor letter out, and it's in the record within a month of finding out in-house and privately how terrible this filter was. You know, this is a filter that had a 430% greater chance of a serious failure or killing you. Those are orders of magnitude, and this is compared to not only competitors, but its own predecessor, something called a Simon-Nightingale filter, which was a superior design. Now,
Maybe it would help me, again, I don't want to ask all the questions, but if you would move to the design defect.
I will.
Now, there you've got Dr., how do you pronounce his name, McMeeking?
McMeeking was a doctor that was called by the plaintiffs in the multi-district litigation before Senior Judge Campbell in the District of Arizona. And Judge Sterrett says that Dr. McMeeking, his testimony created a genuine issue of material fact on the existence of a defect. But with all due respect to Judge Sterrett, he didn't read the rest of the story, because in our brief...
You mean he said, you got a problem here, it's the tilt.
Said we didn't link it up.
It's the tilt, but you didn't link it up to the fracture.
Well, I don't understand why, because Dr. McMeeking goes into a lengthy discussion, and I provided the court with some tab binders.
You did, but here's my question.
But I can answer without
that. Did you
that.
provide those to Judge Sterrett, and if so, in the response to summary judgment, where? Did you tell him?
Either in argument or in one of the exhibits. Yes, it's in the record. He had it.
It's in the record. Okay, because
Yes.
that's really important. You
Everything-
can't expect him to sift through it. He clearly thought, okay, you've shown an issue of fact as to a defect, the tilt. But he obviously, as he wrote, didn't see that you had directed him to evidence in the record that the tilt was equal to the fracture.
Your Honor, my recollection is that that was brought to his attention. That's what I believe happened. I mean, we argued it in court. My colleague who's in the back, who actually argued it, talked about all those matters. And what we had was...
During your rebuttal time, you might provide us an ROA site.
I'm sorry, Judge?
When you're back on during rebuttal time, if you want to provide an ROA site.
I'll look for that, sir. Yes, sir. I've tried to have ROAs for every document, every argument I'm making. But what we had was general causation. Dr. McMeeking also said, here's how these things break, how they migrate. If you will, they're an umbrella, where all the base of the umbrella tips are supposed to be coplanar in a circle. And when they tilt, they become a non-coplanar oval with a non-uniform force being exerted where these legs are joined to the cap. And they break because they stress. Every time your heart beats, the vena cava goes in and out. So over time, it's like bending a coat hanger. It's how these things break. And when they tilt, they break, then they migrate. I mean, imagine a
That's
needle
understandable.
going through a heart.
Now, Bard, as I understand it, you didn't file a reply brief, but their brief responds shifting their argument, saying, first, there's no defect at all. But then more importantly, as I read their brief, we'll ask questions of them, they're saying, well, you never showed that there was a feasible alternative that had the same desirable traits.
Well, that's not correct either. Their own predecessor device, the Simon Nightingale filter, when compared with the recovery filter.
Did McKeegan say that is the comparator? Did he say that's the one to look at? Because remember, Judge Sterrett says, well, where's the law that you can look at a predecessor device?
What Dr. McMeeking did was describe the changes that would create a more reasonable device.
Right, but did he point to, you just said the comparator is the predecessor device. Did he say that?
I'm not aware that he did, but there's also...
Does that matter if he didn't?
You know, Your Honor, that's a tough question to ask when a judge is going through a pile of paper that high. You know, I don't know what I was a clerk for Henry Vance here in the district court 35 years ago, and we had a patent dispute between Shell and Union Carbide. We did our best to read everything, but sometimes you don't. But that doesn't mean it's not in the record. That doesn't mean it's fact.
Let's say it is in the record. You remember his question to you below was, what's the law that allows the feasible alternative to be a predecessor device? And I was therefore looking at your brief to see if you have any law on that.
There's no law that says it either way.
I agree. Okay.
You know, I mean, if you've got a perfectly satisfactory device and you change it to something that works less perfectly, well, shame on the man. Why did they do that? Okay. Now, also in here and listed, featured in our brief is Bard itself in 2004, either in an email or a letter, admitted it needed longer, thicker, stronger legs. It needed various changes in its own device. So Bard itself knew what the reasonable alternative would have been a year before my client got his implant. So, you know, Dr. McMeeking told him what it needed. Bard already knew. So I don't understand why there's a reasonable alternative device argument even.
You think at least there's a fact dispute as to that?
Well, yes, sir. There's a fact dispute over what was disclosed and why they didn't disclose it. There's a fact dispute over what does the word adequate mean? Where's the bright red line? You know, at least in the maritime practice in Chandris versus Latsis, you've got a 30% assignment for the vessel
Would
line.
help us, again, maybe in a reply brief, that to give us some Mississippi law, and that is what we have to apply here. There's no Mississippi law on how we assess feasible alternatives?
I'm not aware of a bright red line case.
Or any case, okay.
And I'm not aware of a bright red line case on what adequate means. Maybe Your Honor needs to say that that's for the jury. That's why general damages in initial disclosures. What are your general damages? Well, I always say it's up to the jury, not me.
Yeah. Okay.
And
You've given us a very strong argument, and you have reserved time?
Yes, sir, I do. Thank you for hearing me. I appreciate it.
We appreciate
Thank you for allowing my clients to sit in.
Oh, of course. All right. Mr. Wainwright?
Okay, Judge Higginson, Judge Willett, Judge Ho, good morning. May it please the court. I'm Dale Wainwright representing appellees, who I'll refer to collectively as BARD. Before I begin my argument, I just want to give the court a heads up. We may request additional briefing. We got at least 16 pages in a purported demonstrative from appellants just before the argument started, and it includes arguments, case law, citations to the record. We haven't had a chance to analyze it, but we may be requesting, well, first we object to it, but we may be requesting the opportunity to reply to this, because on the surface it looks like additional briefing.
Well, you can see, none of us have had a chance to look at any of this, so if it's new material, of course.
I understand, but you will have an opportunity, and if you do, we'd like to have our say.
Absolutely, that's a good point. Thank you.
Thank you, Your Honor. The court has focused in on what exactly is the issue here. It's not the policy. It's not the choices of the legislature. It's to apply controlling Mississippi law, because the case law is clear that any claim for a defective product in Mississippi under the Mississippi Products Liability Act is governed by that act. There are three reasons that provide strong clarity for why exactly what you are asking about, Judge Higginson, is the case. The statute and the constructions of the statute, I'll call the statute the act, govern. First, the act itself, 11-1-63.
But is it a very narrow construction? Because this is an MDL. Would you agree that other cases where your filters are being litigated might not come out the same way, because we're looking at a law that's been construed to be very narrow as to what the warning has to be?
Well, Your Honor, we're looking at a statute that has been drafted to be specific and narrow by the Mississippi legislature and signed into law by the Mississippi.
But it says you have to warn them of dangers. So you could construe dangers to include frequency of failure rates.
I disagree, Your Honor. The statute itself, 11-1-63C2, the provision that defines adequacy of the warning, specifically says an adequate warning, a product warning or instruction is what's at issue. It also says the same thing again in reference to a medical device, that the warning or instruction is at issue. In Wyeth Labs versus Fortenberry, that's the 1988 Fortenberry case, I'll call it Wyeth Labs, says the dispositive question is whether the warning gave to the learned intermediaries is enough to warn of the possible consequences.
Okay, so here, the stark question is, they warned it could fracture and perforate, right? But they didn't. Let's imagine hypothetically, the company knew that happened 9 out of 10 times. Your position is just saying this fractures and perforates would be enough? They wouldn't have to give any indication as to overwhelming frequency of that failure mode?
Your Honor, in our demonstrative 2, there's a chart that just shows the 3 complications complained of, not just 2, 3, the final was embolization, were expressly set out in our warning to Dr. DeVong, the implanting physician.
But my question,
I just wanted to be clear. There were 3 warnings that we supplied, not just 2. We warned of every complication, and Dr. DeVong himself admits, it's in our briefing, that all the complications were warned of in our information.
But not complication rate, frequency rate. That really seems to be the nub. And you're saying in Mississippi that never has to be given? It's always adequate if you just say the end result, death, fracture, perforation?
In Mississippi, extraneous information beyond the warning and the label, including internal documents, emails, any marketing materials which don't apply to BARD. BARD does not market to consumers, to the public, are not to be considered in a adequacy of the warning claim for product defect. In fact, the Mississippi Supreme Court in Fortenberry in 2017 said claimants' attempt in that case to use these very similar documents, emails, promotional materials, and other internal documents.
But Fortenberry, I'm going to interrupt you
expands-
just because I love Fortenberry. I don't see a single Mississippi case construing it to be an absolute rule. That's only been cited 6 times that I know of in Mississippi. No one has ever cited it for that proposition, that the label alone. And the second part, this is just a double-part question for you, unless you know of Mississippi law, is in the Fortenberry case, the label did speak about other drugs. So the warning was as to other comparative devices, correct?
Your Honor, there are lots of ways to kind of slice the bread here.
Okay.
The question is, what is the material information that must be provided in order to make a determination of the adequacy of the warning under Mississippi law?
Yes.
The Supreme Court in Fortenberry said that to include consideration of any of this extraneous material on an adequacy of the warning complaint expands, quote, expands the statutory scope of the claim and is not permissible in Mississippi. Let me talk about this extraneous.
But counsel, listen, this is quoting from Fortenberry. The label also warned that whether antipsychotic drug products differ in their potential to cause the thing was unknown. So see, that label did seem...
What was that last word? Was what?
Was unknown. So the company was saying, well, as to these other drugs, we don't know the risk rate. That could be highly informative to a doctor, right? In other words, their allegation here is that you all knew your product had a very high failure rate and others didn't.
Your Honor, there are other remedies for misrepresentations or fraud.
Are there?
For a claim.
Okay.
For example, here, the appellants sought to amend to assert what they called a valid Mississippi Consumer Protection Act claim. The court said, well past that, you've already amended once, case has been pending a couple of years, it's denied. There may be other remedies for other claims.
I thought Mississippi
but
had
for
sort of
claim for
swept it
product
all into
defects,
this one law. I thought that you really actually can't argue other product liability. I thought in Mississippi, these are your exclusive remedy, no?
Mississippi law is clear.
Okay.
For a claim for damages from a defective product, the MPLA is the exclusive remedy.
So I thought.
But for claims for other things,
Like a misrepresentation.
may be possible to pursue them. Not in this case. We're well past that, of course. Your Honor, let's talk about the parade of complications that you've heard about. Okay, and let me just give you one example of why that really does not get to the point and actually can be misleading. There is, in the record, it's at page 1068 in the record, a health hazard evaluation. In December of 2004, consultants report that Barr had obtained, and in that report it points out, just to explain how numbers can be misleading. You've all heard the anecdote that there are several ways to mislead.
No, but okay, just go on with the point. I'm really interested. You're saying it wasn't as bad as they say it was.
Well, here's the example. There's 42 claims of potential serious hazards from barred filters. There are over 20,000 barred filters sold during that time period. So you're looking at a 0.20% failure rate at most, if these are borne out to...
But my legal question is, accept the allegation that if it were failing at a 9 out of 10 rate, you still say Mississippi law, construed in Fortenberry, would not require any disclosure of that. That's my basic question.
Correct.
Okay.
Under the Mississippi Product Liabilities Act, unless this court wants to rewrite it,
Right.
that cannot be considered.
But the Ninth Circuit Booker decision that you saw in the briefs would allow us to get past summary judgment.
Different states have the right to pursue different
And that's
policies.
Georgia. But then, and I appreciate your brief because they didn't point this out, but in footnote 11, you point out that Judge Mills, former justice on Mississippi Supreme Court, said actually Booker is consistent with Mississippi law. That Munson decision, that's a problem. You think he had, that decision comes down critiquing the one that we're reviewing now. And Judge Mills says, looks to me like Sterrett was wrong.
Very familiar with Munson.
Okay.
Deal with Munson in a footnote. We think it can be addressed very straightforwardly. Munson has an indication in it that it's not really about design defect and adequacy to warn. If that's the case, then it can be distinguished as not an MPLA. Now, it's a suggestion. It's not an express statement. Otherwise, Munson went astray of binding Mississippi Supreme Court law. So there are two ways to address Munson.
Okay.
Respectfully, we disagree with...
It's an extensive opinion. When you say it went astray, it would really help me to know where Judge Mills went astray.
Well, when the warning advises of the specific complications that occur, then, as a matter of law, there is not a claim that can be pursued.
Okay.
Now, Williams versus Manitowoc Cranes was mentioned, opinion authored by Justice Willett in 2018. And in that case, the court said that there was a fact question on adequacy to warn. The court also expressly says the specific complication that caused the injury was not warned about.
Which case is that?
Williams versus Manitowoc Cranes, 2018. Justice Willett probably has a copy for you.
Don't need, okay. You're not, you think in spite of Judge Mills's disagreement with Judge Sterrett here, this wouldn't be something we might want to certify on the failure to warn? You don't think we should ask the Supreme Court of Mississippi, you know, can you clarify if Fortenberry really means what it says?
You know, Fortenberry has a lot of writing in it, a lot of substance in it. It's not a succinct opinion, and I understand why the judge in Munson said it's not clear. However, the points that are relevant in governing this case are very clear. Okay. Another statement from Fortenberry, Judge Higginson. Based on the terms of the Act, the MPLA, quote, the only pertinent question is whether the prescription drug label contained adequate warnings or instructions. The certification might be very quick with an answer. I don't see a reason to certify it, Your Honor, because it is clear. One thing I need to make sure the court understands and kind of clarify the context here that you already heard. No medical device is without risk. No surgery is without risk. Bard and all the manufacturers wish there was a perfect world in that regard. But the point is, Bard filters save lives.
No, right. We understand. What about his point that it was concealed? Is there no evidence of that?
Absolutely not.
No evidence in the record.
Absolutely.
Is that because you do have to report, and you did? Am I right when I say the MAUD database? Is that where doctors could go to and see?
The MAUD database is maintained by the Federal Drug Administration.
Yeah.
And it has mandatory reporting
Okay.
for manufacturers and for importers, and then voluntary reporting for healthcare providers, for doctors, for customers, and for lawyers. It is not verified. It is not. It is conclusory. It is inaccurate because it is just a database of information that's piled in there. So the FDA, through its administrative regulation of this area, will not only have the Mississippi causes of action of the MPLA, the FDA regulates and uses this information to consider its clearance of devices and whether it should look at whether to withdraw them.
My question, I guess, is just if you warn that it could fracture, would an intermediary doctor then be able to go to MAUD and say, okay, well, at least there are a lot of allegations that it is fracturing. They'd be informed, nothing concealed.
MAUD is available to the public.
Okay. Do you want to shift, because I know I asked too many questions. Do you want to shift to design defect? Because my difficulty there is it didn't seem like you were defending the district court's reasoning on its basis, right? You don't agree there's a defect, any issue of fact as to tilting defect. But if we take Judge Sterrett's decision as it stands, then there is. And you heard my question to opposing counsel is, did they point to the testimony of Dr. McKeeking that said that the tilt is what pressures the leg to fracture?
Okay, to answer the first part of your question, Judge, Judge Sterrett's opinion is well-reasoned and it should be affirmed except as to his finding that there was a fact question on design defect. We do not think that's the case because Judge Sterrett's opinion says Judge Murky It says Dr. Murky says that there was, the filter acts as spring, but he never says what the design defect is or how it caused any of the potential complications. So we think that there was no fact question on design defect, and that should have been also ruled in our favor. Now, as to Dr. Meeking's testimony, he again fails to adduce evidence to create a jury question of causation in fact, substantial factor.
He fails to us, or he failed to Judge Sterrett, or both?
Both. The
Because it
review
looks
is
to
de
me in
novo.
his brief now, he is pointing to this extended statement by Dr. McKeeking that's the tilt that creates the pressure that creates the break. And
I don't recall Dr. Meeking saying all that.
Okay.
He did say talked about tilt and potential migration, but causation to a reasonable degree of medical probability, I don't think he gets there on causation, Judge. And even if he does, then we still have the problem of no evidence of a design defect.
And then you have a third answer, which is even if all the above, he didn't create a fact issue as to feasible alternatives. Now, you heard him today say, well, the predecessor device didn't have this failure rate, so why isn't that a feasible alternative?
Your Honor, the reasonable alternative has to have the same utility as the device that Dr. Givon, Mr. Nelson's physician, implanted. Remember, Mr. Nelson was facing an impending liver transplant, which obviously was successful. He was taken off anticoagulants in anticipation of that, so that coagulation would stem any bleeding from the transplant. The filter was implanted, the recovery filter was implanted to preclude clots after being taken off the medication from getting to his lungs or his heart, which could cause catastrophic results. It was only needed, the recovery filter was only needed for a short period of time. After the liver transplant, it would not be needed. Only the recovery filter that the plaintiff's experts talk about was retrievable, removable. It was cleared by the FDA for permanent use and also for permanent use.
Device was not
the SNF, the one that they argue, the plaintiffs argue, is an alternative design, is a permanent device.
What about the
not
predecessor
retrievable.
device? Is that removable? Bard's predecessor device, was that removable?
Your Honor, only the recovery filter would have sufficed here and be retrievable and removable, Your Honor.
And no fact issue as to that?
No fact issue, Judge.
What your best case in Mississippi law about feasible alternatives?
I'm sorry?
Your best case, what would you point us to? I ask opposing counsel, because
Well, there is not a lot of
Not much,
discussion
yeah.
in Mississippi jurisprudence on that point. The statute, however, is clear. The feasible alternative design must have the same utility and be useful, practical, and desirable here. Retrievability was key to use of the recovery filter. Your Honor, there are a couple of points in my remaining time I want to bring up. You mentioned that in a footnote we cited that the appellants made an argument for the first time on appeal. They did not file a reply brief. Under this court's authority, the court could consider that point raised for the first time on appeal waived and not under consideration.
you mean reliance on Munson. Any reliance on Munson, they've waived? Is that what you're saying?
Actually, it is their argument that the warning should have contained information about the comparative rates of adverse events when the IVC filter is removed at 6 months versus left in permanently. They have not responded, and therefore that argument is waived, Judge. I also believe the court should affirm, although I don't think the plaintiffs brought it up, if they did in their brief, that there should not be an opportunity to amend. As Judge Sterrett said, they've already amended once, and the case was well down the road beyond the time for an appropriate amendment. We request that the court affirm Judge Sterrett's opinion and judgment, except to hold contrary to the opinion that there is no evidence of a defective design. Thank you.
Thank you, counsel. Rebuttal?
Your Honor, during my opening remarks, I mentioned that in 2004, Bard knew what needed to be changed in the recovery filter, not the predecessor, the one at issue. And record on appeal, pages 6323 to 6326 and page 7382 detail that email. It's in the record. Also, Dr. McMeeking's discussion of an alternative is found in the record at pages 66, 85, and 86.
Is the alternative the predecessor device?
I'm sorry, sir?
Is that, when I look at that, will that have been the predecessor device?
No, sir. This is what Dr. McMeeking said could and needed to be fixed in the recovery filter, the one at issue.
Yeah, I know, but is the alternative that he pointed to the Bard's own predecessor device?
He did not point specifically to any alternative. He said a reasonable device would have to include the following features.
Interesting. Okay.
Well, I mean, just a reasonable alternative design. You don't have to name competitor A's design. You
Okay,
can
what's
say,
your
here's how
authority?
you fix the problem.
What's your authority that you don't have to point to any existing design? You can just say one could have been done better.
Well, my appreciation is you pass the test when you say, here's what's wrong and here's how you fix it. That's what engineers do.
Okay, I'll take,
I mean,
that's your argument, fine. But we asked you, the specific question we asked for the record site for was?
Dr. McMeeking testified in front of the MDL at a deposition. I wasn't there. I wasn't involved. I can't give you more specific information beyond that. I mean, I tried reading thousands of pages.
I'm not fighting with you, counsel. I'm not asking whether you can give it to me. I'm asking you to point to where you told Judge Sterrett that after McKeeking says, this is Judge Sterrett, his testimony addresses how the design can cause the filter to tilt, but here the issue is fracturing. So where did you point in your response to the summary judgment motion to evidence from Dr. McKeeking that said, well, the tilt is what causes the fracture? That's
Judge, you've got me on that one. I don't know the answer. I don't know if that was part of the brief or whether it was referenced as an exhibit. It was certainly brought up in the Statement of Uncontested Facts, which is 50 pages long. We had 1,300 pages of exhibits in this motion. So
okay, keep going with your argument.
Now, there is a bottom line question of material fact here. There is. And it flows from section C2 that Bard just addressed. And that section says an adequate product warning or instruction, we don't know what adequate means because it's not defined, is one that a reasonably prudent person, meaning Bard, in the same or similar circumstances, having conducted a year-long study in-house to find out what's wrong with their product, and of course, an in-house study is
Keep reading.
Provided with respect to the danger and that communicates sufficient information on the dangers and safe use of the product. They didn't do any of this. They're obligated by Mississippi law. The statute itself required them to do it. And what do they do instead? They hid it. And now they say, protect us behind the four corners of a label. I mean, just sweep it under the rug. Give us a walk, court. Just let us do whatever we want. And if we can hide behind identifying a possible, not certain, not actual facts, 430% greater prospect, but just a possibility, we're off the hook.
You're not asking us to certify to ask Mississippi what adequate means, are you?
Your Honor, I have not thought about asking the court to certify anything because I think a jury is more than capable on a case-by-case basis of deciding under these circumstances with the facts unique to this case, the warning was or was not adequate. I mean, this whole thing is a jury question. That's what amazes me is that we're not going forward to trial. I mean,
Well, it concerns me if you can't point in the record to any filter from any company that says the risk we're warning you about happens to this percentage.
Your Honor, they don't do it because as soon as they do that, they're not in the market anymore. Right. I mean, perhaps I'm being a bit cynical.
All those labels and all those products should go to the jury as therefore maybe inadequate.
If somebody knew something and didn't fess up, yes, that should go to the jury. And in that context, the jury should decide, was the warning adequate? We would not have known this without the MDL. This was hidden. The only company I can think of that did the right thing is Allergan with their breast implants. They said these, we have infamous.
Getting there.
I
Do you have
know.
any final rebuttal points, just because I asked?
Okay.
That's fine, you've made a complete argument. We've got it. But we just have to hear some other cases too.
Okay, also, I think one of
Last point, go ahead.
the last things the court talked about with counsel opposite was what remedies are there out there for this? They're called punitive damages. That's the remedy in a court with a jury.
Thank you, counsel.
That's a remedy.
This case is submitted. Keep going. Keep going. Keep going. Yep. We'll call the third case for the day, 21.